Welcome to Law Office Management. This is a lecture series on Chapter 1 of the Practical Law Office Management text. This is the first of 3 lectures regarding Chapter 1. This Chapter 1 covers a legal team, law practices, and law firm governance. In this chapter, you will learn to discuss the titles and duties of each member of the legal team, explain the trends in paralegal salaries, discuss the different types of law practices, identify alternative law office organizational structures. Chapter 1 sets the stage for the rest of the text. It explains what types of positions and people there are in a law practice, including basic information about practicing paralegals. The chapter is full of current surveys and research regarding what paralegals do on the job, what types of firms they practice in, who typically supervises them, what the ratio of paralegals to attorneys is in different size firms, their compensation, and overtime. The chapter also gives students an understanding of what type of law practices exist, along with the different legal and management structures for law offices. This is the typical list of legal team members of a legal organization. We will explore them in more detail in the coming slides. Attorneys. Attorneys counsel clients regarding their legal rights. They represent clients in litigation and negotiate agreements between clients and others. In legal organizations, there are different types of attorneys based on their organizational qualities. A partner or shareholder is an owner in a private law practice who shares in the practice's profits and losses. A managing partner is chosen by the partnership to run the firm, make administrative decisions, and set policies. An associate attorney does not have an ownership interest in the law firm and does not share in the profits. The associate is an employee of the firm who receives a salary and has no vote regarding management decisions. A lateral hire is an associate who is hired from another firm. A non-equity partner does not share in the profits or losses of the business, but may be included in some aspects of the management of the firm, and may be entitled to other benefits not given to associates. A staff attorney is an attorney hired by a firm with the knowledge and understanding that he or she will never be considered for partnership. A contract attorney is an associate attorney who is temporarily hired by the law office for a specific job or period. When the job or period is finished, the relationship with the firm is over. The title of counsel position is a flexible concept, but generally means that the attorney is affiliated with the firm in some way, such as a retired or semi-retired partner. Of counsel attorneys lend their names to a firm for goodwill and prestige purposes in order to attract additional clients and business to the firm. Paralegals are a distinguishable group of persons who assist attorneys in the delivery of legal services. Through formal education, training, and experience, paralegals have knowledge and expertise regarding the legal system and substantive and procedural law. This qualifies them to do work of a legal nature under the supervision of an attorney. The terms paralegal and legal assistant are, for the most part, synonymous terms. However, there are some differences in the law office governance and the billing structure where paralegals and legal assistants are concerned. We will cover these later in this course. A freelance or contract paralegal works as an independent contractor with supervision by and/or accountability to an attorney. Independent paralegals or legal technicians provide services to clients in regard to a process in which the law is involved, and for those who work, no lawyer is accountable. Legal technicians assist in providing self-help services to the public. A limited licensed legal technician, in states where legislation has been passed, is a person qualified by education, training, and work to engage in a limited practice of law in the approved practice area as per the state's laws. In 2013, Washington passed legislation allowing non-attorneys, under carefully regulated circumstances, with specialized training and certification to practice law in a limited capacity. Other states, such as California and Oregon, have formed task forces to consider the adoption of limited licensed legal technician. In larger legal organizations, a paralegal manager may oversee the paralegal program for the legal organization, including hiring, supervising, training, and evaluating paralegals. One of the wonderful things about having a paralegal education and experience is there are many opportunities for paralegals to work in different areas of legal practice. The National Association of Legal Assistants, NALA, conducted a survey on typical paralegal specialty practices. This exhibit from the textbook shows survey data regarding the types of practices in which paralegals work. As you can see, civil litigation, family law, personal injury law, and administrative/government/public law, including compliance, are very high, as is insurance law. The NALA survey also provided data regarding the types of practices in which paralegals work. As you can see, the majority of paralegals, 61% of those surveyed, they work in traditional law firms, such as private law firms. The fewest number are working in court system or health and medical. The NALA survey also disclosed the size of law firms paralegals work in. The majority of paralegals, 32% of those surveyed, work in firms with 2 to 5 lawyers. The number of lawyers practicing in a firm makes a difference in terms of how a law office is governed, how it handles financial matters, and it matters to the paralegal duties in terms of how many lawyers they might report to. The next slide gives us a picture of that. As you can see from the NALA survey here, the number of, this is a survey chart that shows the ratio of attorneys to legal assistants. So you can see that in a larger firm, a legal assistant might be working for more attorneys than in a smaller firm. The NALA survey disclosed that there is a need for paralegals in all sizes of firms, but with a large attorney population, a paralegal might be reporting to more than one attorney, as opposed to the obvious single practitioner law firm. NALA also gathered information about the compensation of paralegals and what they receive, and among the persons surveyed, it shows that experience certainly has its payoffs. You can see here that if you have over 25 years of experience, the average total compensation, and keep in mind this is a national average, is $65,393. The survey shows the compensation of paralegals by region. Unfortunately, the Southeast region falls behind other regions with an average total compensation of $56,123 per year. Nonetheless, that is a good living. So on the area of compensation, the question is often asked, are paralegals entitled to be paid overtime if they work more than 40 hours a week? The Fair Labor Standards Act, the FLSA, is a federal law that sets minimum wage and overtime pay requirements for employees. Employees do not need to be paid overtime if they fall into one of the 4 white-collar exemptions. That would be executive, administrative, professional, or outside sales. If an employee is exempt, he or she is not required to be paid overtime wages. This would be wages for time spent in excess of 40 hours per week. The issue of whether paralegals are classified as exempt is hotly debated. The U.S. Department of Labor, the agency that administers the FLSA, has long taken the position that paralegals are non-exempt and are entitled to overtime pay over 40 hours a week because their duties do not involve the exercise of discretion and independent judgment required by the regulations, and that they do not fall into the learned profession exemption because an advanced specialized degree is not a standard prerequisite for entrance into the field. The Department of Labor's position has been widely criticized for the ruling because it fails to take into account the recent practice and utilization of the recognized status of the profession, the advanced education, the continuing legal education requirements, the substantive duties performed, and the degree to which a paralegal exercises discretion and independent judgment in the performance of the job. For example, in 1994, in the case of Reich versus Page and Addison PC, a jury found that the paralegals at the Page and Addison law firm were exempt from overtime requirements. Nevertheless, the Department of Labor did not change its general position on the matter. So why are paralegals profitable to a law office? In Missouri versus Jenkins, the U.S. Supreme Court allowed the plaintiff to recover paralegal fees from the defendant at the prevailing market rate for paralegals in the area. The court was interpreting federal statutes, so courts under a different statute may reach a different conclusion. Since Missouri versus Jenkins, many federal and state courts have allowed for the recovery of paralegal billable hours. So, it goes to show paralegals are profitable to law offices because the law office is allowed to charge for the paralegal's time spent working on a case. Moreover, clients are willing to pay for paralegal time. This is because their billing rate is substantially less than what an attorney would charge to do the same work. There are other team members in a law office, including legal administrators who are responsible for some types of law office administrative systems, such as general management, finance and accounting, human resources, marketing, or computer systems. Administrators typically have college degrees in business, accounting, or related fields. An office manager is found in smaller firms and handles the day-to-day operations of the law office, including such activities as timekeeping and billing, supervision of the clerical support staff, assisting the managing partner in preparing a budget, and making recommendations with regard to changes in systems and purchases. Office managers typically do not have degrees in business. A law clerk is usually a student who works for a law firm on a part-time basis while he or she is finishing a law degree. Law clerk duties revolve around legal research and writing. A law librarian is responsible for maintaining a law library, conducting legal research, advising legal professionals regarding research techniques, and managing library resources. Maintenance of a library includes purchasing new books and periodicals, classifying, storing, and indexing books, updating the holdings, and coordinating computer-assisted legal research with tools such as Westlaw or LexisNexis. Legal secretaries or administrative assistants provide assistance and support to other law office staff by preparing documents, composing correspondence, performing word processing and filing functions, and aiding in the scheduling of appointments. Competent legal secretaries have highly specialized skills and perform many services for law firms. Clerks provide support to other staff positions in a variety of miscellaneous functions. Law offices have a wide variety of clerks, including mail clerks, copy clerks, messengers, process servers, file clerks, calendar clerks, and billing clerks, one right after the other. And there are also other legal team members. These include expert witnesses. These are experts who have special technical expertise or specialization in a field, and they agree to give opinions and testimony at trial. Investigators are hired in cases to gather facts and evidence regarding a case. Law offices also use consultants. They use consultants for advice on how to run their businesses efficiently. Law office may use temporary or permanent staffing firms and may outsource projects or services as needed, including copying, mail, record management, and other tasks. Law offices may use a number of specialists, such as computer specialists, bookkeepers, records managers, payroll specialists, and analysts, such as biologists, chemists, and other experts. This concludes Part 1 of the lecture series, a series of 3 lectures on Chapter 1. In our next lecture, we'll cover the types of law practices.